Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where generally we explore religious liberty from the perspective of faith-based nonprofits and cover some of the most important legal issues going on in this world. But we have also increasingly been trying to cover particular topics with experts in these special episodes. So for today's special episode, we're joined by our guest, John Bursch. I think you're the first returning guest. I don't think I've ever had anyone twice. So
That's quite the honor.
couldn't think of anyone better for it.
Thanks.
So I think you need very little introduction for our audience, but John is Senior Counsel and Vice President of Appellate Advocacy at Alliance Defending Freedom, decorated Supreme Court litigator, probably one of the most well-known and respected religious freedom attorneys in the country, also former Solicitor General in the state of Michigan. So one of our favorite people to go to on all things religious liberty, litigation, and appeal. So John, thanks for being back.
My pleasure. Thank you. And you forgot to mention that I'm also a Napa Legal Fellow.
Yes, I probably would have done that in the at the end, but always happy to plug the Good Counselor Project Fellowship. So thank you, and thanks for doing that.
You bet.
All right, so we have potentially a lot to cover. We'll see, maybe two cases, but we're going to start with the main reason that we connected to do this episode is the recent litigation over the Johnson Amendment, but I think it would make sense to back up and talk a little bit about the Johnson Amendment in general. Most of our listeners are probably vaguely familiar, but before we talk about the most recent challenge to it, can you just give us a little context about what the Johnson Amendment is and why it matters for especially our kind of audiences?
Yes, the Johnson Amendment is a bit of a boogeyman for religious organizations and churches who have a 501c3 nonprofit status, which is nearly all of them, because it says that they can't be involved in or intervening in elections. And the government at times has broadly interpreted that to mean any reference to campaigns whatsoever. And as a result, that has scared many priests and pastors and other religious ministers from even talking about controversial issues for fear that they may lose their 501c3 license. So you take a priest at a small Catholic church in a rural community. He really wants to talk about abortion. He thinks that over and knows that abortion might play a role in the outcome of a local election. And he thinks, well, if our little parish loses its 501c3 status, the bishop is going to have my hide for that. And so then he doesn't talk about abortion from the pulpit. So it's been a real boogeyman. It's got an interesting history all the way back to the 1950s because it was introduced by Senator Lyndon Johnson, who we all know as later president. And his beef was that there were religious organizations who were making endorsements in elections that he didn't like. And so he got this introduced specifically to keep 501c3 groups from making political endorsements from the pulpit or otherwise. And it's been in place ever since.
Yeah, I find it fascinating that, because I always chafe a little bit when people talk about, oh, you were granted your 501c3 status, because it's not quite the way the IRS does it. They recognize that you operate for an exempt purpose, and so you're recognized as a 501c3, which is strengthened by the fact that actually churches can self-declare and don't even really need to apply to the IRS. So it's not a government benefit that we've been involved in as an amicus in litigation over that very question. So I think it's interesting if it's not a government benefit. It's something that the government recognizes that you're not the proper subject of taxation. And if that's the case, I find it a little bit shocking that you have to leave a pretty substantial chunk of your First Amendment rights on the ground behind you if you proceed as a C3. But that seems to be what this effectively is, correct?
Oh, absolutely. Yeah, this has been a muzzle on 501c3 organizations for decades. And while churches and other religious organizations and even non-religious organizations have chafed against it, no one has been successful bringing a frontal assault against it until now.
Yeah, and so the NRB case is kind of a watershed movement, but could you movement forward on this issue, but can you talk just a little bit about why that is? Why has there been no successful challenge to something that has been so suspect for decades?
Well, I think maybe there had been a concern on the part of religious organizations that if they push their chips in on the Johnson Amendment, that a hostile federal government might amend the 501c3 laws to take away the exemption entirely, which you'd have all kinds of establishment clause and free exercise claims if that ever happened. But maybe the status quo where we muzzle ourselves sometimes is better than having the fight over whether we have to pay taxes at all. And that's probably a fight that's going to come eventually anyway. You'll recall that famously during the Obergefell argument, which I had the honor of representing the states who were trying to defend marriage between one man and one woman, that the justices asked then U.S. Solicitor General Don Verrilli, well, what's going to happen to tax exemptions for religious organizations who continue to operate on the one man, one woman marriage precept? And he said, well, that could be an issue. And it hasn't happened in the first, 11 years now post Obergefell. But eventually there's going to be an administration and a Congress that takes that on and says, if you're going to discriminate, put that in scare quotes, based on someone's sexual orientation and the way that you hire and fire and teach your beliefs and things like that, then no tax exemption for you. And so I think it's probably better for us to be speaking out boldly about constitutional rights of religious organizations, about the Johnson Amendment, before the reality of those political problems rear their ugly heads.
Yeah. Yeah, there are some cultural and political roads we could go down in response to that. But I think I want to restrain myself and talk about this case because it's a fascinating case. Now, can you just give, before we go into the legal issues that were at play, just a little bit of the background, plaintiff's posture, what's going on with this NRB case?
It's 4 plaintiffs, the national religious broadcasters, 2 churches, and then 1 religious organization that does voter guides. And they all had concerns about being able to endorse candidates, wanted to endorse candidates, and knew that the Johnson Amendment was going to prohibit that and it would put their 501c3 status at risk. And so they filed a lawsuit, and this was in the waning days of the Biden administration. And the Biden administration immediately filed a motion to dismiss. They said there was no standing, that the court lacked jurisdiction, all those procedural hurdles. But then when the election changed the administration, the new Department of Justice came in and basically said, we think you have standing. We don't think there are any jurisdictional hurdles. And we think that your legal claims are right, which we can get into in a few moments. And so they basically stipulated to the entry of an injunction that would allow churches to endorse candidates at the pulpit. It wasn't as broad as saying you can participate in the political process writ large. So, for example, you couldn't have a church actively working on behalf of a candidate. But it went a long way towards solving some of these censorship problems. And unfortunately, the district court rejected the stipulated judgment with the federal government on the grounds that doing so would violate the Anti-Injunction Act. And we can get into that too.
Yes. So before we get into the turn of events with the dismissal and then the appeal, so it was entered into, it's something of a settlement agreement, right? So would this have been, if it were accepted, this still would have signaled where this administration's IRS is on the issue, but it would not really be a binding precedent. Is that right?
That's correct. And the judgment would be a binding precedent, though with respect only to these parties.
Right.
Now, that said, once the government enters into a stipulated judgment that its law can't be enforced because it's unconstitutional, that will typically be followed in the ordinary course by some administrative proclamation that the administration will no longer be enforcing this rule because it's unconstitutional. And so that would essentially create writ large an opportunity for every religious 501c3 to engage in candidate endorsement.
And the other thing I would just point out or make sure I have right. So regardless of what happens after, right, it's an agreement that's only binding on the parties. It was then rejected and the case was dismissed. Now it's on appeal. But that aside, I think it still does signal probably to churches that at least during this current administration, they're probably not coming after pastors speaking about candidates. I wouldn't give legal advice if I were representing a church saying now you're good to go, but it seems that it is a pretty strong signal of where the current administration is on this issue.
Yeah, that's absolutely right. And if you're, say, a Catholic priest, who has some concerns, like the main thing to understand is you can talk about marriage and you can talk about abortion and you can talk about IVF and you can talk about surrogacy and you can talk about gender ideology from the pulpit. And that was never a problem before, But now it's really not a problem because you have the administration waving the white flag. And if you wanted to go farther and test the waters in the same way that these plaintiffs did and that the Trump administration has now acquiesced in, you could say from the pulpit, all right, you've got a vote coming up in November for a U.S. Senate seat in our state. And here are the issues that the Catholic Church cares deeply about. And here are where the candidates stand on these issues. And while you each have to examine your own conscience and come to your own conclusions about voting, it'd be really difficult for a Catholic in good standing to support candidate X when they are pro-abortion, pro-gender ideology, pro-same-sex marriage, and all these things. So I hope that this will inspire some of the clergy to be more bold about speaking on these issues.
Yeah, it's interesting. I know the USCCB came out. I think it was Catholic Church is pretty quick to shy away from the frontiers maybe opened by this. But I think you make a more important, like bigger picture point that there are very extreme sides to how religious organizations react to like the Johnson Amendment and these general political and advocacy prohibitions. You have, on one hand, I think you see this more in the like evangelical non-denom church world that people they just go all in. They are saying very political things, and there seems to be very little concern for the IRS. And then you see what you had said that the campaign intervention laws and some of the lobbying restrictions make these nonprofits or these churches so gun shy that they won't even talk about like issue advocacy if it touches on political issues, which is way beyond what the IRS would ever require of religious organizations. So
right, it's extending the muzzle of censorship in a way that the federal law doesn't even require. And it's interesting that you talk about the differences in churches. That's a really good segue to the primary legal claim that the federal government invoked in the stipulated judgment that the district court eventually rejected, because there are a number of ways that you could talk about why the Johnson Amendment is unconstitutional, how it impinges the free exercise and free speech rights of these religious organizations, who, like you said, this isn't a benefit, it's just restricting them. You could talk about how there are other 501c3 groups like veterans and things like that who don't have the same kind of muzzle, and that disparate kind of treatment is, a paradigm tandem free exercise problem. But what the federal government focused on in the stipulation was actually the way that this affected different churches differently, depending on what their beliefs were about a priest's or pastor's role at the pulpit. And it said that for those denominations that consider it an essential part of religious inculcation to be able to talk about candidates and how you vote and things like that, it affects them much more severely than a church that doesn't think that that's an essential part of inculcating the faith. And that creates a Catholic Charities problem, where you'll recall the Supreme Court said with respect to Wisconsin Catholic Charities, that simply because some groups would lean into providing social services, taking care of the homeless and the hungry and things like that, without an express evangelical message accompanied with it, compared to others that would, like every single service is accompanied by an evangelical message, that differential treatment is itself a free exercise problem. And so the court focused, or I'm sorry, the administration focused on that same differential type of activity and how the law treats them differently, and invoked Catholic Charities as the reason why the Johnson Amendment couldn't stand.
yeah, that's a great point. I'm glad to hear someone who actually has the ability to use this, like you, talking about this, because I've been floating this idea for whenever I get the chance to speak on these issues, that the reasoning in Wisconsin Catholic Charities is very applicable to a lot of the cases that are now heating up. I think like the cases like St. Mary's v. Roy, there's a lot of untapped potential there to say, well, hold on, Carson v. Macon, we lost on that. You can't just discriminate against the religious schools for being religious, but we can discriminate against the religious schools that won't hire LGBT people. This feels to me like an application of something like Wisconsin Catholic Charities. You're now saying, okay, some religious organizations get the benefit, but not the religious organizations that are bad and do this thing. It starts to feel like the Establishment Clause argument that was, unanimous in Wisconsin Catholic Charities. Anyway, I know I'm getting us far.
You're 100% correct about that.
Good. I'm glad to hear that from you. Thank you. Then I will keep talking about it. All right. So we have this. Yeah, the settlement agreement was was interesting. It signaled some important things. And then I saw the headline a couple months ago that it was rejected and now this was back in court. And that's when I heard from you about it. So can you just say quickly what happened? Because I know it's a little bit of a legal niche issue as to why the settlement agreement was rejected and it was dismissed.
Yeah, there's a federal law, the Anti-Injunction Act, and it's specifically in place to prevent people who have a tax liability from going to court and getting a federal court to enjoin the collection of taxes. Instead, they're supposed to pay the tax and then appeal it and go through the ordinary processes that way. And the underlying policy behind the AIA is that it's important that the court, oh no, sorry, that the government continue to be able to collect tax revenues. And you can't have people making frivolous objections and then tying up their payment of tax revenues for years. So that makes some sense there. Now, the federal government chose not to invoke the AIA as a defense to this lawsuit. Instead, they entered into the stipulated judgment. But the district court, on its own, sua sponte is the fancy Latin that the lawyers use, decided to apply it anyway. And that put the whole settlement on ice because the court concluded it didn't have jurisdiction to take it. But the court was wrong about that, and that's what we're going to be arguing to the Fifth Circuit. We just filed our opening brief a couple of weeks ago. And the differences between this type of case and the ordinary tax collection case that I just described to you are multiple. Here, there's no tax that's said to be owed yet. And this isn't a challenge to the amount of a tax or the fact that a tax was assessed or anything like that. Instead, it's a challenge to a speech restriction, to the censorship that's happening. And if the court did not allow this type of a challenge to go forward, then by using the auspices of the inapplicable AIA, it would allow the government to continue to censor and cause religious organizations to chill their own speech until some perhaps unlikely series of events took place that would result in the assessment of a tax. That would mean that a priest or a pastor would have to make a statement from the pulpit. It would have to get reported to the IRS. The IRS, maybe not even in this administration based on their position, but in a future administration would have to say, okay, that's the end of your 501c3 status. And then the following year assess taxes based on that. There's just this whole hypothetical string of things that needs to happen when churches are chilling their speech right now. There's a First Amendment injury happening right now. And the interesting thing about the AIA, wholly aside from the merits of its inapplicability to a situation like this, is that it's almost certainly just a procedural doctrine, not a substantive one, that the government is free to waive anytime they want. And we know that because when the Congress wants to create a jurisdictional bar to something, the language is directed toward the courts. And the AIA language is directed toward the parties. Jurisdictional things are all in one part of the U.S. code. The AIA is in a different part of the U.S. code. And so if it's not a jurisdictional rule, it's merely a procedural processing claims rule, then it can be waived. And the government clearly did, not only by not invoking it, by continuing not to invoke it after the district court brought it up. So it's been waived, forfeited, however you want to describe that. And so it really shouldn't be a barrier to the entry of the judgment that the parties all agreed on. And that'll be the issue teed up for the Fifth Circuit.
So are there both it was waived and it's not a jurisdictional bar, so the sua sponte application was inappropriate, and then also are the substantive arguments about the inapplicability of the AIA, are those also up on appeal?
Correct. Yep.
Okay.
All of those are fully briefed for the Fifth Circuit to decide. And
excellent. So,
those questions about the scope of the AIA, whether it's jurisdictional or not, as well as the substantive scope, are the types of issues that could make it to the Supreme Court, depending on what the Fifth Circuit does with it. And there is an intervening party, the separation of church and state folks, which shouldn't be a big surprise. And so even if the Trump DOJ does not want to take this case to the Supreme Court, if, for example, the court rules in favor of the plaintiffs, then they undoubtedly will try to do that.
Interesting. So where are we in the process now? Briefs are in, and is oral argument scheduled?
Not yet. The opening briefs are in, but the responsive briefs and reply briefs have yet to be filed. So, if I'm guessing, I would say oral argument, December or maybe the first part of next year, with a decision probably in spring or early summer of next year.
Great. Yeah, this is another one of those cases that I really wanted to cover, especially after the dismissal and appeal, because often you have these things where it's not the spicy headline grabbing substantive legal issue that's actually at play, but the boring stuff, like we jokingly call it, is actually really important for religious liberty. I think of cases like First Choice, right, that just was heard in the Supreme Court this year, and then the year before that South Carolina v. Medina case, where you're arguing pretty obscure areas of law. It's not really about the abortion issue per se, or here the religious liberty issue per se. But the technical practice of really hard legal doctrines is actually going to make the difference in whether religious rights can be protected and vindicated. So thank you for doing it.
It makes a huge difference. And I had the privilege of arguing the Medina case, which was the defunding Planned Parenthood at the state level case. And then ADF, I was part of the Supreme Court team on First Choice. And you'd be surprised at how frequently tiny little procedural dust-ups can result in monumental wins for religious liberty and for life.
Yeah. Well, glad to have people like you leading the charge. So speaking of leading the charge, I know it was not originally scheduled programming, but you told me before we started that the U.S. Supreme Court granted cert in a case that we've covered on our podcast in the past. And so I wanted to spend a few minutes on it. And I don't remember the case name, but his name is Daniel Grand, right? This was
Yes, it's Grand versus City of University Heights, which is a Cleveland suburb.
And it's pretty quixotic. I had a hard time believing the facts that this guy was organizing basically a prayer with a few other Orthodox Jews right in his house, and was told that he needed to basically, I mean, I'm paraphrasing, you can go into the details, but like permit his house as if it were a house of worship, or else he couldn't pray with his friends in his own house. So is it as crazy as I just made it sound?
It absolutely is. He had sent out an email inviting about a dozen friends over to his home. It's a mandatory practice for Orthodox Jews that they get together in a group of men with at least 10 people in it for prayer several times a day. And that can be difficult if you don't have a temple nearby on a Sabbath, because they're not allowed to drive their cars on that day. And in this case, the nearest temple is several miles away. And so you have to rely on getting a ride from a non-Orthodox Jew, or just walk that couple of miles. And the prayer group in the home seemed like a good solution to that. But someone got wind of the email and they forwarded it to the city's mayor. And he didn't like what was happening and had the law department immediately issue a cease and desist letter telling Daniel that he and his friends were not allowed to pray in a small group at his home unless they had gone through the requisite permitting process, which is absolutely bizarre. And Daniel called the mayor and clarified, I'm just talking about maybe a dozen or so men praying together in my home. There's not going to be any traffic concerns. None of us are going to be driving. We're all walking to my home. And the mayor says, yes, you are prohibited from doing this. You need to have a permit as a house of worship. And so he applied for that permit, appeared in front of a zoning commission that was open hearing to the entire public. Numerous people turned out, said that they didn't want to be known as a Jewish neighborhood in this part of the city, and that they wanted the city to turn this down. And as part of that process, he realized for the first time that if he was successful and got the permit the city demanded, that a house of worship prohibits residential living. And so he and his family would have to vacate the very place that they wanted to have a few friends over to pray in. And so he went to court. And this is to your point about the importance of procedure. Federal District Court and then the Sixth Circuit Court of Appeals agreed that the case had to be dismissed. And their beef was that Daniel had not finished the permitting process. He had not waited until the zoning commission said yes or no on this permit that he didn't want. And his point at the Supreme Court is that the free exercise violation happened immediately. As soon as the cease and desist order came out and prohibited prayer at his home, there was no need to exhaust any permitting remedies, to do any further paperwork, to go through another hearing where people could yell their anti-Semitic comments. The constitutional violation was already in place, and he deserved to have a court hearing over that. So remarkably, Daniel represented himself in filing the cert petition. As you know, it's very, very rare that a pro se litigant without a lawyer can get a cert petition granted. So he files that. The justices got it. The city waived its right to respond, which is common when you've got a pro se litigant. And the justices directed the city to respond. Well, as soon as that happened, then the legal world kind of woke up. Hey, the justices might be interested in this. And so Alliance Defending Freedom and Oric, a large national civil law firm, are co-counseling Daniel at the Supreme Court. We filed the reply brief and they granted cert on June 30th, and we expect that oral argument will take place in December. So it's a procedural question. Do you have to exhaust permitting remedies to allege a free exercise and RLUIPA violation when you've already suffered a concrete injury to your prayer rights? And it's one that I expect the Supreme Court will rule overwhelmingly in our favor, but one that will make a difference for millions of Americans, because you can imagine how easy it would be for a city to stop any religious exercise by simply saying, oh, you need a permit for that. And then delaying that process for years before you have a final decision that you can actually go to court with.
It seems to me like a particularly strong set of facts to argue this issue. I mean, besides the obvious reasons, but because the zoning process that they're telling him you need to complete before you are ready to go the federal court route wouldn't grant him the proper remedy anyway, right? Because if he got
Exactly.
it, he'd be a house of worship and then he can't live in his house, from what you've said. So this doesn't
Yeah.
solve the problem whether he gets it or not.
It would be completely futile. And
Yeah.
the point that we make is that you can suffer injury from a zoning commission's actions, in this case, the city issuing the cease and desist order, without them actually making any decisions on the merits at all. And that's exactly what happened to Daniel and his family.
Wow. This is one of those, some cases are closer than others, but this is one of these, the founders are proverbially rolling over in their graves, I think, to have a whole process like this to deny somebody the ability to. It's especially good because even the common objection of traffic and parking is not there because they're Orthodox Jews on the Sabbath, so they're walking there. So there's literally nothing. This gets as bad as like the people being punished in England for praying inside their houses too close to an abortion clinic. Like it's so. I mean, even if it was public, it's fine, but this is such a private action that literally does nothing visible in the public square. It's just kind of shocking that this went this far.
Well, and we haven't even talked about the rest of the facts because the whole permit to pray thing was only the beginning. The city had police cars driving by the home to make sure that there weren't excessive number of people gathering there. They asked the neighbors to spy on the home and to report if there were a lot of visitors coming over. One of the neighbors actually installed cameras pointed at the house so that he could keep a constant vigilant watch to make sure that this wasn't being turned into some secret prayer house. The city trash periodically stopped picking up his trash for no reason. They cited him with all kinds of bogus property violations about having an illegal driveway that was made out of some gravel, which had no basis in the law at all. So the persecution was rampant and it continued long after the initial cease and desist demand, as well as that hearing. So the whole thing is remarkable. And it gives the court an opportunity to clarify something. And I'll get very legal geeky here just for a second for all the lawyers who are watching. There is a Supreme Court case called Williamson County, which says you have to exhaust your permitting remedies before you bring a takings claim. And that's really what the Sixth Circuit invoked here. They said, well, because this involved a zoning issue, even though it really didn't, then you have to follow the same exhaustion requirement that you do in a Williamson County taking situation. Now, the court has backed away from that ruling in some other contexts, but critically, it has never applied it anywhere outside of the takings context. And you brought up first choice. Specifically in that case, Justice Gorsuch, writing for the unanimous court, said, we've never applied Williamson County to a non-takings case, and we're not going to even discuss that issue here. Well, this is their opportunity to do that, to take this doctrine, which has no application outside of the takings context, and expand it in a way that prevents litigants from going to court when Section 1983 civil rights claims were intended to throw the federal court doors open to folks who had had their constitutional rights violated by local government officials. So I do think that the court is likely to rule favorably, and hopefully it'll do so by cabining that Williamson County principle only to takings cases and not expand it.
Great. So cert was granted, so that's for this coming term, this will be heard?
Yes, yeah. The opening brief on our side is due end of August, early September, right around that time. Amici briefs, if folks are interested in filing them, are due right after Labor Day. And we've been notified that it'll be heard sometime on the court's December argument calendar.
Okay, very good. All right. Well, we covered two of the issues that we seem to be spending a lot of time on lately, Johnson Amendment related issues and then RLUIPA land use cases. So thanks so much for coming in and filling in on a couple of the hot cases right now in our world.
Yeah, my pleasure. Anytime.
It's always good to have you, John. So thank you, as always, for giving us some of your valuable time. And thank you to our listeners for joining us for another episode of the Napa Legal Podcast. As always, if you enjoy the content we're putting out, we always appreciate it. If you like the podcast, subscribe to our channel on YouTube or Spotify or wherever else we have it up. And we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. So we'll talk to you all next week. Thank you for joining us, John and listeners, and God bless you all.